to this seminar. At the outset, I would like to welcome and President of this today's seminar being conducted by the Bar Association of Ongole and Sreenivasulu. Thank you, sir. I request Chandra Suresh of Ongole Bar Association to present a bouquet to the Honorable Chairman, Sri Ganda Ramarao Garu. Thank you, sir, for your kind acceptance. Acting Chief Justice also a couple of weeks ago. Sir, please, we request you wholeheartedly to come out the dais. And please adore your chair, sir. Now I request Makal Ramamurthy Garu from Ongole Bar Association as well as High Court Advocate and Supreme Court Advocate to present sir with a bouquet. Thank you, sir. Now I request Honorable Justice Dr. K. Manmadharao Garu, Judge of Andhra Pradesh High Court, to come over the dais and advocate the chair. From Ongole Bar Association only. So it is very congratulatory thing and happy thing for Sir's elevation as High Court Judge who hails from this Prakasam district. Thank you, sir. Now I request Sheikh Usman Saab to present a bouquet to Dr. Manmadharao sir, Justice. Thank you, sir. Now I request Honorable Miss Justice B.S. Bhanumati Garu. I request Srimati M.H. Deepulata to present a bouquet to Honorable Miss Justice B.S. Bhanumati Garu, High Court of Andhra Pradesh, and the Portfolio Judge of Prakasam District. Thank you, ma'am. I request the Honorable Principal District and Sessions Judge Ongole, Srimati A. Bharati Madam Garu, to come out the dais and adore the chair. Madam Garu. Thank you, ma'am, for having accepted our bouquet. Now I request the Vice Chairman, Bar Council of Andhra Pradesh, Sri K. Ramjogeswara Garu, to come out the dais and adorn the chair. I request Sri Badipur Sreenivasulu Garu, Advocate from Ongole. Now I request the Honorable Member, Bar Council of India, Sri A. Ramireddy Garu, to come out the dais and adorn the chair. Bar Association Ongole to present a bouquet to Sri A. Ramireddy Garu. I request the Honorable Member, Bar Council of Andhra Pradesh and Public Prosecutor of High Court, Sri Y. Nagireddy Garu, to come over the dais and adore the chair. Who hails from our bar, Ongole Bar, to present a bouquet to Y. Nagireddy Garu. Thank you, sir. Last but not the least, I request the President, Bar Association of Ongole, Sri N.S. Sreenivasulu to come to N.S. Sreenivasulu. Thank you, sir. So today's seminar is being conducted under the sponsorship of BAR as well as the local law college, which is always ready to extend its support for our legal fraternity programs, Indira Priyadarsini Law College, Ongole. So here, huge gathering, especially the advocates and students. Out of this seminar, all of us will be benefited as the renowned personalities, high-profile justices are going to deliver their keynote addresses in this seminar. And because of the active participation, I wish I am Chittam Venkateswarlu, advocate from this Ongole Bar Association. Once again, I welcome you all and wish you all the best for our program. Now, with this, I hand over the mic to Sri Ganta Ramarao Garu, Chairman, Bar Council of Andhra Pradesh, to preside over the function. Thank you, sir. Please.
Sri Deepti.
स्मरामि वसिष्ठ वामदेव दिवन्दित गणपतिं मनसा स्मरामि वसिष्ठ वामदेव दिवन्दित गणपतिं महाकाव्य नाटकादि प्रियो महाकाव्य नाटकादि प्रियो मूषिक वाहन मोदक प्रिय महागणपतिं मनसा स्मरामि वसिष्ठ वामदेवादिवन्दित महागणपतिं वन्दे मातरम् वन्दे मातरम् सुजलां सुफलां मलयज शीतलां सस्यश्यामलां मातरं वन्दे मातरम् सुप्रजोष्णा पुलकितयामिनी पुल्लकुसुमित द्रुमदल शोभिनी सुहासिनी सुमधुर भाषिणी सुखदं वन्दे मातरम् वन्दे मातरम्
Now the next is writing of the one-time program for residential program. We are trying to reach every district, nook and corner of the state by conducting this program. And I thank the Bar Association for coming forward. This is since long time, it is 1 year back it was conceived, this idea at Ongole. But one reason or other it has been postponed. Ultimately it is materialized today. And I thank the judges, honorable judges, for accepting readily to come and address us on this occasion. And I also take this opportunity, the college who came forward and associated with us. In almost 6 to 7 years back, Bar Council of Andhra Pradesh has conducted a similar program at Ongole. And after formation of the new state, and now we almost 7 districts we completed, and still some more. We have been minimum 1 month or at least one program, and in certain wherever the occasion come, opportunity come, in July we are able to conduct the 2 programs on 22nd July at Nalluri and 29th July at Vijayanagaram. And every month at least one minimum program we are planning, so that we can complete and reach every corner of the state by conducting this program. And for any success of the program, main is a participation. Maybe many of us or some of us know the law, we are capable of even addressing others. But still, these kind of programs, once you attend, and a different angle you can see, and it's a time to stop and think what we are doing, how we are doing, whether we can improve our knowledge. Because unlike other professions, we are lacking behind compared to other professions. Now, I proudly can say that Andhra Pradesh Bar Council is the second in entire country, and we are trying to cross the Maharashtra within a short period. We may be able to cross the Maharashtra and become the first position in conducting these kind of programs. I always say and share that necessity of establishing a lawyers academy wherever we go and try to impress upon them. We have been trying, and within a short period we will be able to form and promote and establish a lawyers academy at appropriate place. I hope and trust that each one of us will play our role, and by establishing, and we will have a permanent infrastructure, so that we can continue this kind of orientation programs, intensive training programs, and so that we can abreast of what are the developments in the profession. I don't want to take much time, and I also request our friends to spare the time, so that we can, the purpose for which we assembled will be served. Now I request Ramakrishna Garu, the secretary and correspondent of the Priyadarshini Law College, to give his message, only not more than 2 minutes. Please come and give the message.
And as well my friends and colleagues, respected elders, this is a great opportunity for all of us to have the legal luminaries today in Ongole to address us on 3 very important topics. This is an occasion where we all have to be very attentive while hearing to these great speeches, or rather a great advocates who are going to give us eloquent speeches on very important topics which are beneficial to our legal fraternity. Today, I am especially happy because Indira Priyadarshini Law College, which has been established in Ongole 30 years back is now in its new premises, and we were given the privilege of hosting our guests there. So my students who are now in the college have attended this meeting good in number, and virtually we have declared a holiday for the college today with the hope that they all will attend these seminars, which they rarely get. It's a rare opportunity for all of them also to hear such speeches on very important topics. So I thank the Bar Council of Andhra Pradesh, as well the Bar Association of Ongole, and my managing committee headed by our Dr. Narsimharao Garu, the President, to get this opportunity of co-hosting this program along with the Bar Council and Bar Association of Ongole. We are all waiting for the great addresses that are going to be given to us by our most learned my lordships. And I don't like to take much of your time. So I thank the President, Andhra Pradesh Bar Council, for conducting this program in Ongole for one reason, and for giving us an opportunity to participate in this and to be the co-organizers or in coordination with us also. The Bar Council of India, Ongole, has taken a lot of pain to make this program a success, for which I am also a member of it. So I thank one and all for having given me this opportunity. I especially thank Sri Ganta Ramarao Garu, and I also thank our most learned judges for coming over to Ongole to address all of us. Thank you, sir. Thank you very much.
I request Ramareddy Garu.
Respected my brother Ramarao Garu, who is President of the program and the Chairman of the Bar Council of Andhra Pradesh. Today's our chief guest, Justice Ongole Venkat Sheshai Garu, guest of honor Dr. K. Manmat Rao Garu, and Justice B.S. Bhanumati Garu, and Principal District Judge Bharati Garu, my esteemed brother, Vice Chairman of the Bar Council Ram Jogeswara Garu, my colleague friend Y. Nagireddy Garu, Member Bar Council of AP and Public Prosecutor, and Ram Krishna Garu, President Ongole Bar Association, and present district and senior and junior judges of the Ongole district, my colleague, members of the Bar Council, and senior and junior advocates, my dear students, good morning to everybody. This is not time to speak to me because we are all waiting for the hearing of the Honorable Judges' lessons. Actually, I am first time attended the Ongole seminar. Last time 7 years back conducted, but I was not attending that program. This time, I thanks to Nagireddy and Ganta Ramarao Garu and Indira Priyadarshini College to conduct this seminar. Very happy. The seminars or workshops or orientation programs, it is a continued legal education training programs. Throughout the country, the Bar Council of India planning to conduct training programs. At the same time, the Maharashtra and Goa Bar Council conduct a continued legal education training program. That is India #1 in the country. Now in Andhra Pradesh, after bifurcation of the Andhra Pradesh, we are conducting every month a training program. We are in the #2 position. We hope, as our President says, we will go to #1 position. The Bar Council of India planning to construct a law academy at Goa. Already started Goa one International India Law University last year itself. Now next month it may be foundation by the Honorable Chief Justice of India. Maybe September or October, land was allotted by the Goa government. And also Andhra Pradesh also planning to law academy in 3 regions, Uttarandhra, Coastal and Rayalaseema, 3 regions. First of all, we thankful to our senior most Judge Ongole Satya garu. మనకు బార్ కౌన్సిల్ దొరికిన ఏకైక ఆనిముత్యం వారు హైకోర్టు జడ్జిగా అపాయింట్ అయినప్పటి నుండి అంటే దాదాపు 2013 నుంచి కూడా బార్ కౌన్సిల్ ఎక్కడ ప్రోగ్రామ్ పెట్టినా కూడా ఎంత బిజీ షెడ్యూల్ ఉన్నా కూడా నో అనే మాట వినకుండా వారికి వేరే ప్రోగ్రామ్ ఉన్నా బార్ కౌన్సిల్ ఫిక్స్ చేసే టైంకు వారు రావడము వారి వాల్యుబుల్ టైంని వెచ్చేసి ఇక్కడ మనందరికీ ఈ క్లాసెస్ చెప్పడం అనేది నిజంగా ఆంధ్రప్రదేశ్ లీగల్ ఫ్రెటర్నిటీ కానీ జ్యుడిషియరీ కానీ చేసుకునే అదృష్టంగా భావిస్తూ వారి ప్రత్యేక ధన్యవాదాలు తెలుసుకుంటాం సార్. అదేవిధంగా మానవేంద్ర నాథరాయ్ రాయగూడ వారు కూడా చాలా ప్రోగ్రామ్స్ అటెండ్ అయినారు. బట్ ఈరోజు రావాల్సింది బట్ సమ్ టెక్నికల్ కారణంగా రాలేకపోయారు. ఇంకా మీ జిల్లా సన్నాథ సాయిల్ మన్మథరావు గారు వారి స్పీచ్ చాలా అద్భుతంగా ఉంటుంది. వారితో వింటే గారు ప్రాక్టికల్ మ్యాన్. మేమందరం కూడా ఫస్ట్ టైం మాకు అనంతరం వచ్చినప్పుడు ఇండిపెండెన్స్ డే రోజు ఆయన స్పీచ్ వినడం జరిగింది. అంతకుముందు ఒకసారి కేఎల్ యూనివర్సిటీలో వినడం జరిగింది. చాలా డెప్త్గా ఉంటున్నాడు ప్రాక్టికల్గా. ఇంకా మేడం భానుమతి గారు కూడా సివిల్ సైడ్ మంచి జడ్జి కాబట్టి వారు చెప్పి కూడా వినాలి. అడ్వకేట్లు కోరుకుని ఒక్కటే ప్రతి అడ్వకేటు ఎక్కడ సెమినార్ ఉన్నా ఎక్కడ మీటింగ్ ఉన్నా ప్రతి చోట యూ మస్ట్ బి అటెండ్ ది ప్రోగ్రామ్. దేర్ ఓన్లీ యూ హ్యావ్ లర్నింగ్. ఎవరు ఎక్కడ అంతమందిలో ఒక్క 2 పాయింట్లు నేర్చుకోగలిగినా కూడా మన అడ్వకేట్కి ఒక సార్థకత ఏర్పడుతుంది. అది తెలుసుకోవాలా. మనకెందుకు వెళ్ళి బార్ కౌన్సిల్ ఏదో పెట్టుకుంటున్నారు, బార్ ఏదో చేస్తున్నారు అనే కార్యక్రమం కాకుండా మనం వెళ్ళాలి, ఖచ్చితంగా అటెండ్ కావాలి, వినాలి అనే ఒక కాన్సెప్ట్తో అడ్వకేట్ ఏదైనా సీనియర్ అడ్వకేట్ ఆ జూనియర్ అడ్వకేట్ ఎవరైనా సరే ఇది సీనియర్లే కానీ జూనియర్లే అనుకోకుండా స్టూడెంట్స్ కానీ ప్రతి కాన్ఫరెన్స్ కూడా విని అటెండ్ అయ్యి వినాలని కోరుకుంటున్నాను. చాలామందికి అదిగా మనం ఎందుకు వెళ్ళాలి, నాకంటే వాళ్ళకి ఎక్కువ తెలుసా అనే భావన ఉంటుంది. అది పక్కకు పెట్టి మనం కూడా తెలుసుకోవాలా. లాయర్లు కానీ జడ్జెస్ కానీ నిత్య విద్యార్థులు మనం. అందువల్ల రైట్ ది బార్ కౌన్సిల్ ఆఫ్ ఇండియా కూడా ఈ సిఓపీలు కానీ ఇవన్నింటిలో కూడా కడప్ చేస్తుంది. భవిష్యత్తులో ఇంకా మొన్ననే తీసుకోవడం జరిగింది ఇన్సూరెన్స్ పాలసీ, నేషనల్ వైడ్ ఇన్సూరెన్స్ పాలసీ తీసుకోవడం జరిగింది. వితిన్ 1 మంత్ లోపలే కంట్రీ వైడ్ 23 లక్షల మందికి ఇన్సూరెన్స్ పాలసీని బార్ కౌన్సిల్ ప్రవేశపెట్టబోతోంది. అందులో అంతేకాకుండా ఈ అడ్వకేట్ ప్రొడక్షన్ యాక్ట్ కూడా సబ్మిట్ చేయడం జరిగింది పార్లమెంట్కు. అది కూడా పరిశీలనలో ఉంది. వితిన్ 1 or 2 months అడ్వకేట్ ప్రొడక్షన్ యాక్ట్ కూడా తొందరలో పార్లమెంట్లో ఆమోదించబడుతుందని తెలియజేసుకుంటూ ఈ అవకాశం ఇచ్చినటువంటి మీ అందరికీ ప్రత్యేక ధన్యవాదాలు తీసుకుంటూ సెలవు తీసుకుంటాం. థ్యాంక్ యూ.
The Honorable Vice Chairman Bar Council of AP to give his message.
President of today's function, Sri Ganta Ramarao garu, Chairman Bar Council of Andhra Pradesh, our Chief Guest, Honorable Sri Justice Ongole Satya Sreenivasulu garu, Judge, High Court of Andhra Pradesh, Honorable Sri Justice Sri Dr. Justice K. Manmohanrao garu, Judge, High Court of Andhra Pradesh, Honorable Miss Justice P.S. Bhanumati garu, Judge, High Court of Andhra Pradesh, and Administrative Judge, Prakasham District, Srimati A. Bharati garu, Principal District and Session Judge, Ongole, my brother A. Ramireddy garu, Member Bar Council of India for the State of Andhra Pradesh, and Sri Y. Nagireddy garu, Member Bar Council of Andhra Pradesh, State of Andhra Pradesh, and State Public Prosecutor of Andhra Pradesh, Sri N.S. Sreenivasulu, President District Bar Association, Ongole, my co-Bar Council members, judicial officers, senior and junior advocates. Very good afternoon. I am appreciating Ongole Bar Association and Sri Indira Priyadarshini Law College and Sri Nagireddy garu for organizing this grand seminar. In fact, it is a matter of pleasure that our Bar Council is organizing this type of seminars across the state to educate advocate fraternity, particularly young advocates. Due to drastic changes in the global economic policies and corporate entities, and also the availability of technology, the importance of law became very prominent. At the same time, the litigants are, whether they may be corporate litigants or private litigants, they are trying to learn the legal knowledge through and with the help of internet and artificial intelligence. At this juncture, it is very necessary to the advocate fraternity to update themselves the latest laws. Otherwise, it is very difficult to sustain our profession. Not only now for profession, but also in any profession. For upgrading our knowledge or legal skills, these type of seminars are very useful, where the eminent legal experts are going to deliver the lectures. Particularly, it is very useful to the upcoming advocates also. Our society expects the bar to render their services with fair and fearless manner, so as to bring peace, prosperity and development to one and all. So, to meet the expectations of the society, our bar councils prescribes standard professional conduct and etiquette, and they are exercising their judicial jurisdiction also. So no doubt, I am having confidence that our legal fraternity is the beacon light of our society to provide services to the needy and poor people. So, one and all, thank you very much.
I request Nagireddy, son of the soil, to give his message.
President of today's seminar, Sri Ganta Ramarao Garu, Honorable Chairman, Bar Council of Andhra Pradesh, Chief Guest of today's function, our beloved Judge, Honorable Justice A.V. Seshai Garu, Senior Judge, High Court of Andhra Pradesh, Guests of Honor, Son of the Soil, our beloved Judge, Honorable Justice K. Manmadarao Garu, Judge High Court of AP, Guest of Honor of today's seminar, Honorable Judge Justice B.S. Bhanumati Garu, Administrative Judge and Judge High Court of Andhra Pradesh, Member Bar Council of India, Sri A. Ramareddy Garu, Sri K. Ramjogeshwarao Garu, Vice Chairman, Bar Council of Andhra Pradesh, Sri N.S. Sreenivasulu Garu, President, Ongole Bar Association, Srimati A. Bharati Garu, Principal District and Sessions Judge, Ongole, my colleague Bar Council members, senior advocates, advocate friends, and Indira Priyadarshini College law students, media persons, I am very thankful to you for attending this seminar today. Good morning to all of you. I am very happy to stand before you as a member of the Bar Council, and I am also associated with this Bar Association 2.5 decades ago as an apprenticeship while I was doing apprenticeship under the guidance of late Karavadi Venkateswarlu garu, who is the freedom fighter and a stalwart in civil side. And I got an opportunity and I got that privilege to observe so many eminent advocates from this bar. And few names I can say now. When I go back to the memories of 1998-99, I used to see KV garu, CV garu, VHP garu, V Hariprasad garu. I'm sorry, short names, because in Ongole it is custom to call them with short names. KS garu, Krupasagar garu, KRR garu, MRR garu, and others, so on and so forth. Due to past of time, I cannot say the names. And at the same time, criminal side, Sunkara Dasharatha Reddy garu, Hanuma Reddy garu, he is before us, Mohan Das garu, and D. Sreenivasulu Reddy garu, DVR garu, and so on and so forth. I am sorry to say that I cannot say the names of all the persons, but these are the lessons. I got an opportunity, I have had the privilege to observe them while I was doing the apprenticeship here 2.5 decades ago. That's why I scared to speak before you also now. In fact, I deem it a privilege as member of the Bar Council to conduct seminar here on behalf of the Bar Council, and today I stand before you because of your support. I elected as younger Bar Council member of Andhra Pradesh. I feel it proud. In fact, it is the duty of the Bar Council, the functions of the Bar Council. Section 6 of the Advocates Act 1961 clearly says that Bar Council not only admit the persons as an advocates on rolls, they have to safeguard the privileges of the advocates, interests of the advocates, and they have to see the welfare of the advocates. Apart from all those activities, it is the bound duty of the State Bar Council to impart legal education to the needy advocates. In fact, as part of the legal education, our Bar Council has initiated a good step throughout the India. Only after Maharashtra, our Bar Council only is conducting seminars. So far, our Honorable Chairman already informed that at 6 places we have already conducted seminars. But due to COVID, in the year 21-22, we could not conduct the seminars, but now those seminars were resumed, and last month we have conducted successfully at Vizianagaram, and prior to that at Nellore, and now it is the time for Ongole. I am very thankful to all the advocates for attending the seminar. At the same time, these seminars are very important to abreast our day-to-day laws. Now, the speakers are very eminent in their field. After going through, after completion of this seminar, definitely we will get the benefit, and it will become an indicator for us tomorrow to see the CPC limitation and evidence in different perspective, because their experiences, their 1 hour class equal to our 1 month study of CPC. 1 hour class of the limitation definitely useful for our 1 month rigorous study of the Limitation Act. Likewise, because of our interaction, because every day we are all the advocates are the law students. Evidence, Limitation Act, because only 3 lectures today. These 3 definitely from tomorrow onwards we will see in different perspective. While we are studying CPC, we see in our own perspective. After going through the lecture, definitely it is very useful for us, and we will see in different manner, and we will also get it. It will become an indicator for us too. That's why it is definitely useful for all of us. I am very thankful to our honorable judges for readily accepting the invitation of the Bar Council. It is not their, in fact, obligation to come, and because they have their own administrative work and they have their own they have to deliver the judgments. Their time is very precious. In spite of that, taking toil, they are taking very risk and they are coming here. I am very thankful to you, sir, for all of you from the bottom of heart for coming here to deliver the lectures. And I wish that this seminar definitely will be useful to all the advocates and law student perspective. Thank you one and all for giving an opportunity to me.
Thank you, Nayak Garu. Now I request Srimati A. Bharati Garu and Principal Sessions and District Judge Ongole to give her message on this occasion.
Good morning to all of you. I convey my reverential pranams to Lordships, Honorable Sri Justice A.V. Satya Garu, Senior Judge, High Court of Andhra Pradesh, Honorable Dr. Justice K. Mohammad Rao Garu, High Court of Andhra Pradesh, and Honorable Miss Justice B.S. Bhanumati Garu, Administrative Judge of Prakasham District, for participating in this seminar. It is also my privilege to congratulate Sri Ganta Ramarao Garu, Chairman, Sri K. Ramjogeshwar Rao Garu, Vice Chairman, and Sri A. Ramireddy Garu, Member of the Bar Council of India for the State of Andhra Pradesh, Sri Y. Nagireddy Garu, Member Bar Council of the State of Andhra Pradesh, and Sri N. Sreenivasulu Garu, President Bar Association Ongole, and team of organizers and participants for choosing this district for conducting the seminar in the august presence of their lordships and ladyship for presentation on the following topics in order to emphasize on topics touching more crucial aspects. Civil Procedure Code with special reference to Disposal of IAS, Limitation Act and Evidence Act relevancy for the benefit of legal fraternity, judicial officers, advocates and students of law college. I am very happy for being part of this seminar, which could certainly help all of us in enhancing our knowledge on the topics which are going to be presented by their lordships. All of us do not have equal talent, but all of us have an equal opportunities to develop our talents, as quoted by Honorable Dr. APJ Abdul Kalam Garu. Indeed, law is a evolution and continuous process of learning. There cannot be any barriers in improving our legal knowledge and awareness because it changes from time to time. Everyone has to update their knowledge in all branches of law for effective functioning, either for presenting the case before the courts or for deciding the issue involved in the cases. This is a best occasion to all of us, and we have to avail this opportunity to develop our skills in our profession. Like all of you, I am also eagerly waiting for hearing the honorable judges on the topics assigned for enhancing knowledge to render our duties more effectively. With this brief note, by thanking the chairperson of this seminar for giving me this opportunity, I take leave with the permission of their lordships, thanking you all one again.
Thank you, madam. I am proposing to deviate from the regular program because already we are delayed. So we have to cover up by the today program to deliver His Lordship's inaugural address, also and continue the first session so that we'll be able to cope up with the delay. Thank you. I call upon Justice Seshasai Garu to inaugurate the seminar and also commence the first session.
సంపదను తృణప్రాయంగా త్యాగం చేసిన మహనీయుడు, ఈ జిల్లా ముద్దుబిడ్డ, ఆంధ్ర రాష్ట్ర ప్రథమ ముఖ్యమంత్రి శ్రీ టంగుటూరి ప్రకాశం పంతులు గారికి ముందుగా శిరస్సు వంచి నమస్కరిస్తూ ఒక్క విషయం మీ అందరితో పంచుకోవాలండి. బహుశా 8 సంవత్సరాల క్రితం అనుకుంటా, ఇంచుమించు 1.5 సంవత్సరాల కాలం పాటు ఈ జిల్లాకు నేను పోర్ట్ఫోలియో జడ్జిగా ఉండటం జరిగింది. ఆ సమయంలో ప్రిన్సిపల్ డిస్ట్రిక్ట్ జడ్జిగా శ్రీ కేవి విజయ్ కుమార్ గారు ఉండేవారు. చాలా కార్యక్రమాలు చేసేవాళ్ళం. ఆ సమయంలో చాలా తరచు కూడా నేను వస్తూ ఉండేవాడిని ప్రకాశం జిల్లా. ఏ చిన్న కార్యక్రమం జరిగినా, ఏ మారుమూల ప్రాంతంలో జరిగినా సరే తప్పనిసరిగా నేను సునీల్ చౌదరి గారు, అంటే సన్ ఆఫ్ ది సాయిల్, ఇద్దరం కూడా వస్తూ ఉండేవాళ్ళం. విజయ్ కుమార్ గారు ఒక మాట అడగడం జరిగిందండి ఆ రోజుల్లో. పీడీజే గారు, సార్ మీరు చిన్న చిన్న కార్యక్రమాలకు కూడా ఈ జిల్లాకు వస్తూ ఉంటారు కదా, ఈ జిల్లా అంటే మీకు ఎందుకంటే ఇష్టం అన్నాడు ఆయన. నిజం చెప్పమంటారా అన్న? చెప్పండి. టంగుటూరి ప్రకాశం పంతులు గారు వారి జన్మస్థలం ప్రకాశం జిల్లాయే కదండి. జన్మస్థలం ప్రకాశం జిల్లా అయినా సరే ఆయన కార్యస్థలం మాత్రం మా జిల్లా అండి, గోదావరి జిల్లా అన్నది. చాలా సంతోషించాడండి. అది నా అనుబంధం ఈ జిల్లాతో. ఇక president of this wonderful event and the president, chairman, bar council of the Andhra Pradesh, captain of the fraternity in the state, Sri Ganta Ramarao garu, my sister and brother judges, learned principal district judge, learned senior advocates, other dignitaries on and off the dais, my heartfelt pranams to one and all. As rightly said by the preceding speakers, all of you know, the only thing that multiplies on sharing is the knowledge. డబ్బు పంచుకుంటే పెరుగుతుంది కానండి, నాలెడ్జ్ మాత్రం పెరుగుతుంది. సో ఆబ్వియస్లీ విత్ దట్ ఇంటెన్షన్ ది బార్ కౌన్సిల్ ఆఫ్ ఆంధ్ర ప్రదేశ్ for last so many years has been organizing the programs of this nature. For this great service they require lots and lots of appreciation. Sir, one thing is, unlike other professions, right from the inception, the members of legal fraternity are called learned members of the bar. Learned. What is the reason behind this? That is the respect we command in the society. So we need to be up to those expectations of society. Then how to retain that position? In order to be so, we should have knowledge in abundance. So for achieving the same, undoubtedly the programs of this nature would be of immense help, as rightly said by Nalluri garu. Therefore, I request all of you, not only the present members of the bar, but also the future members of the bar, law college students, to avail this wonderful opportunity. And I also request all of you, especially the younger members and the future members of the bar, to kindly interact. Don't hesitate to interact. Kindly participate actively in this program. Finally, I thank one and all here for giving this wonderful opportunity of participation in this great event. So, President Garu, shall I begin the session now? Yes, coming to the present session. Let us begin this session by offering salutations to two great and versatile personalities of the yesteryears. One is Jatipita Mahatma Gandhi ji. Another is father and the author of the Constitution, Bharat Ratna Ambedkar ji. Dear friends, very often we come across one thing. Very often we hear this. It should be done in accordance with law. It should be done in accordance with law. What is the meaning of this law? Is it defined anywhere? Young members of the bar, so also the students of law. Please interact, sir. Yes, anybody from the participants? I don't say audience, participants only, you are participants. Dear students of law of a prestigious institution named after a great leader of our country, Indira Priyadarshini. What is the meaning of law? Please participate. Let there be beginning from the younger members of the bar. Not one way. I don't believe in that. స్టూడెంట్స్ ఎవరైనా సరే, నేను ప్రకాశం పంతులు గారి మాట ఎందుకని చెప్పారంటే, ఆనాడు ఆయన మద్రాసులో సైమన్ కమిషన్కి ఎదురొడ్డి ఇక్కడ కాల్చండి అన్నాడు ఆయన. అది ధైర్యం ప్రకాశం జిల్లా వాడిది. ప్లీజ్ కైండ్లీ పార్టిసిపేట్ సార్. ఎవరైనా సరే చెప్పండి అమ్మా దయచేసి. వాట్ ఈజ్ మెంట్ బై లా? లా అంటే ఏంటి? ఈజ్ ఇట్ డిఫైన్డ్ ఎనీవేర్? ఎస్ అమ్మా, somebody is raising the hand.
Law is nothing but common sense. Law is a set of rules and regulations which are bound for the welfare of the public. Simple.
Law is nothing but common sense.
Yeah. In other way defined.
Rules and regulations.
Yes.
Good. Anybody?
Indira Priyadarshini Law College.
You are a lecturer now.
Not previously.
Previous.
Now I am member of this bar association.
Yes, I'm very glad.
It's like nothing but common sense codified, I feel.
The codified common sense is called law.
Yes. Which is enforceable in the courts of law.
Very good, Amma. Excellent. Excellent. Of Article 13 of the Constitution. Another doubt of mine is, can there be a law? Can there be a law contrary to the Constitution? Can there be a law contrary to the provisions of the Constitution? Yes, please. Anybody? Supposing a law is made by Parliament or a state legislature which runs contrary to the provisions of the Constitution, what should happen? Yes, Amma, please.
The precedents, the traditions and the customs which are prevailing in the society, though they don't match with the codified laws, they too can be implemented in the society. And when they come in contrast with the existing and codified law, the custom alone will prevail.
My doubt is, can there be a law? Another is procedural law. Substantive law and the procedural law. అసలు ఈ సబ్స్టాంటివ్ అంటే ఏంటి, ప్రొసీజరల్ లా అంటే ఏంటి? Sir, please kindly participate. What is meant by substantive law? What is meant by procedural law? Is there any difference between these two? How to demarcate? What is the distinction between these two? Substantive law deals with the rights and liabilities of the parties. Substantive law deals with the rights and liabilities of the parties, whereas the procedural laws prescribe the mechanism and procedure for enforcement of the rights and the liabilities. This is about substantive and procedural laws. In this scintillating event, today, I have been asked to speak on Civil Procedure Code with special reference to interlocutory applications. As I said earlier, it is not a speech, it is only interactive program. I would like to share my thoughts on this within the four corners of law. All of you know, the Code of Civil Procedure 1908 regulates the procedure which needs to be adhered to in civil courts. CPC or Civil Procedure Code was codified. When it is codified, when it came into being, came into force. Anybody from the Amma? From which date it came into force? 1st January 1909? Correct, Amma? 1/1/1909. And all of you know, this Code of Civil Procedure has undergone a number of changes or amendments. The last one being when? A massive amendment, a massive change took place. When recently? 1/7/2002. 1/7/2002. Last amendments. Then all of you know there are 158 sections and 51 orders in the CPC. Then some important provisions of law under the Code of Civil Procedure. I don't say that others are unimportant. They are also important. Some important provisions of law. First one is section 9 of the code. Section 9 of the Code of Civil Procedure is the first one today. Would anybody elaborate on this? Section 9. Youngsters from the bar. Amma? Mic only. Please give the mic. Yes, sir, please. Civil nature. Section 9 stipulates what? They are coming nearer. Coming nearer. According to this provision of law, courts of civil jurisdiction are empowered to try all suits of civil nature unless they are, as correctly said by our sister, barred either impliedly or by express provisions of law. What is meant by implied and what is meant by express? Another doubt of mine is that what is meant by implied, the term implied and express? Supposing in a special law made, there is a provision which expressly bars the jurisdiction of the civil court, that is called express bar. And in the special enactment, if there is an alternative mechanism provided, then that is called implied bar. I think I am correct. Then another important provision of law is section 10 of the CPC. Next provision is after 9, 10. Sir, anybody from the participants? Section 10. Section 10, what does it say? What does section 10 say? Because day in and day out we come across these provisions of law and the interpretation thereof. Yes, somebody is raising the hand there in the back. Yes, sir. One participant, or sister. A mic is coming to you.
అదే కాసు మీద ప్రవేశపెట్టలేము.
Is it res sub judice or res judicata? There is slight difference, Amma.
Yes, sir.
Res sub judice, res judicata. Supposing there are two suits.
Subsequent suit will be stayed.
That is the purpose. Title suit, so also permanent injunction.
Yes.
Which suit has to be stayed now?
The subsequent suit.
First suit is comprehensive suit.
Yes.
Second suit is a mere injunction.
Yes.
Now, which is to be stayed? Second suit.
If the issues are same involved in those suits, then subsequent suit will be stayed.
Supposing second suit is a comprehensive suit, which suit has to be stayed?
Second suit.
That is permissible.
Yes. When issues are same, then subsequent suit only will be stayed.
According to provisions of section 10 of the Act,
Yes.
only subsequent suit or the second suit can be stayed.
Yes.
Antenandi?
And then.
First suit injunction suit andi.
Yes.
Second suit comprehensive suit. Then serial చెప్పండి. What is the object behind this?
Because if the former suit is decreed, it can bind over the subsequent suit as res judicata. The order will be as a res judicata. It applied as a res judicata on the subsequent suit. So one suit should be tried for one cause of action.
Obviously, to avoid the multiplicity
of the proceedings
and the conflict of decisions.
Yes, sir.
Yes, sir. Thank you very much. So, another provision of law, sister was pointing out, is section 11 of the Code of Civil Procedure. Section 11 of the Code of Civil Procedure, which deals with the res judicata doctrine. What is barred under this provision of law? Kesama, now your turn has come. You are saying something. Amma. Yes, Amma. Please tell now. What does this provision say? And what is barred under this provision of law? ఏమో చెప్పండి అమ్మా. తెలుగు చెప్పండి. పర్వాలేదు. తెలుగు చెప్పండి తల్లి.
సార్ ఒకసారి కేసు ఫైనల్ అయిన తర్వాత లోయర్ కోర్టులో మళ్ళీ అదే కాసు మీద వేరే కోర్టుకు వెళ్ళకూడదు.
Between the same parties.
Yes, sir.
What is the object behind this? Is there any object sought to be achieved?
సార్ అదే జడ్జిమెంట్లో కాన్ఫ్లిక్ట్స్ రాకూడదనే ఉద్దేశంతో.
This safeguards the litigant from the onslaught of frivolous and vexatious litigation.
Yes, sir.
And it gives finality to the litigation also at the same time. That is the object behind this.
Yes.
Supposing you are aggrieved by a decree rendered by a trial court, decree passed by a trial court. What is the remedy open for the aggrieved party? What is the remedy? Supposing there is a judgment decree rendered against you, what will you do? What will you do? You will file appeal. You will file first appeal. First appeal is provided under. You have a district court here. Day in and day out you file appeals. Under which provision of law you file the appeals? What is the substantive provision? Yes, Sabha, kindly participate. Yes. First appeal needs to be filed under which provision of law? Yes, sir. Somebody is raising the hand. Sir, mic. Please give the mic.
'96 of CPC.
Procedure is governed by which provision of law? What is the procedure?
Procedure is
96 is the substantive provision of law under which you file the appeal. First appeal, appeal suit. What is the procedure? Under the order. Correct? 41 rule 1. Yes. First appeal, all of you know, it's a right of appeal. Second appeal, sir. You are aggrieved once again by the first appellate court's judgment. 100. What is the difference between these two provisions? Section 96 and section 100.
Substantial law or procedure? Substantial law or that is
96 is right of appeal. Like the judgment and decree rendered by the first court, trial court.
That is a substantial law. This is a procedure of law.
Section 100 deals with the second appeals.
Second appeal.
What is the condition precedent for filing second appeals? There should be substantial question of law. Unless a substantial question of law is shown in a given case, second appeal cannot be entertained at all. What is meant by substantial question of law? It's another question, another issue. If you find difficulty with English, you can say in Telugu also.
Substantial law means, for example, IPC. Just for a substantial law, for example, IPC.
Anybody? What is meant by substantial question of law? Substantially impacts or affects the adjudication of the issues is called substantial question of law. Then, all of you know, as I said earlier, last amendments to CPC took place in 2002. In certain cases, those amendments barred the filing of the second appeals. That is 100A. Wherever the value of the subject property, wherever the value does not exceed 25,000, second appeal is barred. Is it barred in all cases or only in some cases? 100A. 100A of CPC says only in money suits wherever the value does not exceed 25,000, second appeal is barred. Then you may entertain another doubt. Second appeal is barred. Why not a revision before the High Court? చిదంబరం గారు నేను కూడా ఈ పరిస్థితి ఎదురైందప్పుడు మాకు సెకండ్ అపీల్ బార్ చేశారు కదా, వై నాట్ రివిజన్ అండర్ 227 అని రివిజన్స్ కూడా వేశారు కొన్ని కేసుల్లో. We used to file. Yes, our High Court, composite High Court said, when appeal is barred, where is the question of filing the revision? Now it is set at naught, kadandi? Right. Another important provision of law is Section 151 of the కోడ్ ఆఫ్ సివిల్ ప్రొసీజర్. ఈ తారక మంత్రం ఇది 151. ఎవరైనా చెప్తారా దీని గురించి? ప్రతిరోజు మనం పిటిషన్స్ వేస్తూ ఉంటాం. మెయిన్ ప్రొవిజన్స్ రాసిన సార్ రెడ్ విత్ 151 పడేస్తాం బై అమెండ్మెంట్ కాషన్. ఎస్, ఎవరన్నా సరే అదండి సెక్షన్ 151 ఆఫ్ ది కోడ్ ఆఫ్ సివిల్ ప్రొసీజర్. వుడ్ ఎనీబడి? Codes have inherent power under section 151 of the Code of Civil Procedure. Yes. Yes, sir. Somebody is saying here.
Caveat petition, sir. Caveat petition.
Caveat petition. Under section
151.
151. May not be correct. Yes.
When there is a specific provision to deal the petition, that time the section 151 is prevailed to get orders from the honorable. And also for
by amendment caution we do that, Amma.
Yes, sir.
When there is a specific provision, can we file or no? We cannot. We have to avoid that provision of law. Then, since we are dealing with, thank you very much. Since we are dealing with the interlocutory applications today, let us focus on certain applications, because due to time constraint we cannot cover all the applications. Then before going further, we should know what exactly the object behind these interlocutory applications. What exactly the object behind this interlocutory applications we should know first of all, before going into the further details. What is the object behind this? Please participate, Amma. Please interact. Students kuda evaraina sare, don't hesitate. మీరు చెప్పాలనుకుని చెప్పేసేయండి. Applications are intended for preservation of the rights of the parties pending litigation,
Yes.
pending final adjudication of the issues.
Yes.
I am correct?
Yes, sir.
Yes, sir. Thank you. Thank you very much. Then, I would like to place before you certain important interlocutory applications which we come across very often in our day-to-day administration, day-to-day transactions, adjudicatory process. First application is Order 1, Rule 10. Order 1, Rule 10 of the Code of Civil Procedure. This provision of law deals with what? So there are so many youngsters, sir. Please kindly participate. Cheppandamma.
Parties.
What is the object behind this provision of law? Is there any particular object behind this provision of law? For insertion of this provision of law in the code?
In process of filing a suit in wrong names or wrong persons, in those circumstances we can add any other names who are related to the case.
Then what is the condition precedent for filing these applications? What is the condition precedent? Something should be in existence in order to avoid this remedy. What is that? One should be a proper and necessary party. Thank you, ma'am. And another contingency is the presence of such party should be necessary for adjudication of all the issues finally and effectively. Make a note of these judgments, may be helpful to you. AR 1999 Supreme Court 976. Then 2012 3 ALD 128 and 320. Then 2005 6th volume Supreme Court cases 733. I have one doubt here. So far as Order 1 Rule 10 is concerned, I have one doubt. In a suit for specific performance of contract of sale, a person who claims the right independent of the agreement of sale, can he be permitted to come on record under Order 1 Rule 10? No. Yes, sir. Seniors are not clarify cheyiste. No. Seniors cannot clarify. Sir. చూడబోతా సరే బడ్జెట్ సార్ ఇక్కడ ఇవ్వండి సార్.
The aggrieved person having a right over the property can impede. And he can
So third parties cannot be permitted to come on record.
In a specific performance recent judgment 2020, in case of a property was transferred by a party, the alienee cannot be come forward on record by the apex court judgment.
Pending suit.
Pending suit.
Yes, anybody. They filed an application to implead themselves as defendants in the suit. Trial court dismissed that application. Then the matter came up by way of revision to the High Court. What should I do? Should I leave the parties to the A? Fact remains, defendants, they remained ex parte. Nobody was there to contest the suit. It is a suit for specific performance of contract of sale. Should I allow them to come on record or I should not? Yes, sir. That is a distinction, slight distinction is there. Should we allow? So to avoid the multiplicity, we should pave the way for them to come on record.
And because of the parties are said ex parte, and there may be a collegial decree may obtained by suppressing with regard to truth by applying a fraud on the court itself. In such circumstances, the court feels, and if he is having any right, the person who come forward on record by way of filing Order 1 Rule 10, the court shall allow that application and impede him and put a matter.
Thank you, sir. You have confirmed my view. Thank you very much, sir. Yes. Then a necessary and a proper party, whether can be impleaded in appeal at the appellate stage. You may get a doubt, since he was not a party in the suit, he lost the opportunity to contest. Yes, can be filed. That is 2006, 5th volume, Andhra Law Times, page number 1. Then in a final decree proceedings, in a partition suit, can there be such impediment under Order 1 Rule 10? In final decree proceedings, can we permit the parties to come on record? He comes up with an application saying that the decree is likely to affect my rights. In those circumstances, can we permit the party to come on record? Yes. That is 2015, first volume Andhra Law Times, page number 454. Another peculiar situation cropped up in one case. trial court rendered a judgment. Then appeal was filed before the appellate court. In that particular case, appeal was filed before the High Court. By impleading the judge who passed the judgment, by impleading the judge who rendered the judgment in the trial court, what should we do? Is it permissible? Judge గారిని ఇంప్లీడ్ చేశారమ్మా అపలేట్ కోర్టులో. Should we permit such course of action? ఈ కేసులు మానేసి ఆ కేసులు చేసుకోవాలి. ఏమా కెన్ హీ బి impleaded in such a manner? No. That's what the Honorable Supreme Court also said. So also our High Court, composite High Court, that is 2014, 3 Andhra Law Times, 590 Division Bench. Another issue is, in a given case, in a suit, defendant dies. Admittedly, plaintiff, he doesn't take any steps to bring the LRs on record under Order 22. Time is over. Then in that particular case, cleverly an application was filed under Order 1 Rule 10. LR application వేయకుండా Order 1 Rule 10 application వేశారు. మనం ఎంటర్టైన్ చేయొచ్చా లేదా? Such application is maintainable or not? Yes, anybody? Should we permit such course of action? Admittedly, he failed to file an application to bring the LRs on record under Order 22. Still, Order 1 Rule 10 is available. Yes, sir. Available according to you. Good. Anybody? When he fails to avail the opportunity under 22 within the time prescribed by the statute, whether such application to implead is maintainable under Order 1 Rule 10. Yes, sir. Yes, sir. Can it be filed, sir? Cannot be filed? Cannot be maintained at all?
Prevails. And after the lapse of that statute, we got Article 120, 122 of the Limitation Act. 90 days and abatement to 60 days.
Abatement, other things.
60 days. After lapse of 150 days, Section 5 of limitations prevails. And if these people are not in a position to come forward with applications to avoid a long time, the advocate will avail Order 1 Rule 10 to avoid this 300 days, 500
Sir,
days.
is it maintainable, sir?
Generally, it is not maintainable.
Specifically also not maintainable. That is 2005 Law Times 705. Our High Court said such application cannot be entertained at all. Then you also come across land acquisition appeals. ఓపీస్ వేస్తారు కదండి. ఓపీస్ వేస్తే ఏం చేస్తారంటే, సపోజింగ్ A, B, they make an application for reference. They expressly protest under Section 18 of the old Act, I'm saying. Then their matters are referred to civil court, competent civil court under Section 18 of the Act. Then one prudent litigant, rather a wise litigant, files an application. In fact, it was filed an application under Order 1 Rule 10 to come on record as one of the claimants in the OP. Should we allow that? Sir, Chancellor garu cheppandi sir. Chancellor garu iవ్వండి.
Only government alone has to add them as part. The person cannot come before them. Reference, after reference.
Correct, sir. Such application cannot be entertained at all. Application is maintainable. After commencement of trial, whether an application under Order 1 Rule 10 is maintainable or not. Yes, sir, you are correct, sir. It is clarified by our High Court, 2015, third volume, Andhra Law Times 31. Then, that is about Order 1 Rule 10. The second application is 31, sir. 31, sir. 2015, third volume, ALT 31. That is broadly about Order 1 Rule 10. Then, coming to the next application, appointment of commissioners. What is the relevant provision of law? Section 75 and Order 26. For what purposes this application, these type of applications can be filed? For what purposes? For examining the witnesses, to make local inspection, to examine the accounts, to make partition, then to hold scientific, technical and expert investigation, and to conduct sale of property, etc., etc. So you may get so many doubts while referring to this provision of law. Can a commissioner be appointed for the purpose of collecting the evidence? For the purpose of collecting the evidence, whether commissioner can be appointed or not? Yes, sir.
Cannot be appointed.
Cannot be done. Sir, sir, I have one more doubt, sir. I want to get it clarified here. Whether a second commissioner can be appointed. Whether second commissioner can be appointed. Supposing there is a commissioner appointed, his report is already there on record before the court. Whether for the same purpose a second commissioner can be appointed?
No.
No. What is the course open for the party aggrieved?
He has to get it redirection in case of any clarification he wants through same commissioner. In case the first commissioner passed away or is not in a position to come forward and to revisit the same properties, then the court has got ample power to make it reappointment.
It can't be done unless the first commissioner's report is issued. Scrap.
Yes.
That is 2017 fifth volume, 2017 fifth volume, Andhra Legal Decisions 1-3. Then in a simple suit for injunction, whether commissioner can be appointed. In a simple suit, injunction simpliciter, a commissioner can be appointed. Is there any exception? Normal rule is cannot be. When there is a dispute as regards identity of the property, in such circumstance, in that contingency, this can be done. Then, third one is Order 38 Rule 5. Attachments. Attachments. Anybody from the youngsters, under what circumstances an attachment application can be filed? And what is the object behind this? Object is preservation of the rights of the parties to the litigation. Then, very often you get a doubt. Supposing property is situated outside the jurisdiction of the court, whether an attachment can be done or not. Under what provision of law? Sir, please. First is correct, sir. What is required to be done under that provision of law? Is it to be sent to the court Yes, it has to be sent to the concerned court where the property is situated. Correct, sir. You are correct. That is 1996 4 Andhra legal decisions, 1137. Another doubt is, when a property is attached, pending suit, that is before judgment, and when EP is filed, further attachment is necessary or not? Property is attached to pending suit prior to judgment. In EP, in fact, that objection was raised in a particular case. Since there is no attachment in EP, you can't execute it. Not necessary, sir. This is governed by Order 38 Rule 11, sir. Not necessary. Supposing there is an attachment order, suit is dismissed for default. Then an application was filed for registration of the suit. Application allowed. Automatically the attachment also gets revived or does not get? Can be revived. Automatic revival would be there or not is the question. It does not. Yes, you are correct. That is Rule 11, capital A, Clause 2 of Order 38 takes care of this. Order 38, Rule 11 A2, AR 2003, Karnataka 128. The next important provision of law, which we come across very often in our day-to-day, that is Order 39. Anybody from the youngsters, what are the ingredients of Order 39, Rule 1 and 2? From the youngsters, what are the necessary ingredients which need to be shown by the party applying for this? Yes, sir. Prima facie case? Yes, sir. You are saying something. Please. Please, sir. Give the mic.
There should be prima facie case. Balance of convenience should be leave to the petitioner, and irreparable and immediate loss should be there.
These three ingredients are mandatory.
Yes.
Isn't it, sir?
Yes, sir.
Then, supposing an application is filed and Order 39 Rules 1 and 2, application is dismissed, what is the remedy open for the party aggrieved?
He can file CMA.
Yes, sir.
Civil miscellaneous application. Yes.
Under? Supposing an injunction is granted or injunction is refused, the remedy of appeal is available under Order 43. You are correct? 43. In a given case, an application is filed for injunction. Then, court granted status quo order. Not an injunction, nor an order refusing to grant injunction. It's merely a status quo order. Then a revision was filed before the High Court. Whether it is maintainable or not is the question. Brahmanand Reddy wanted to say something, sir. అది రిజెక్షన్ కాదు, అది అలానే ఇంజెక్షన్ కాదు, అది స్టేటస్ కో అండి. అకార్డింగ్ టు ఇట్స్ అన్ అపీలబుల్ ఆర్డర్, ఇజంట్ ఇట్?
That no injection is ordered or either
no injection is refused.
That is the position of today's order.
No. Let us see. There is another law also. I will say that also. What is the remedy open? It is neither injection nor an order refusing to grant injection. అంటే పార్టీస్ కొట్టుకునే పరిస్థితి రాకూడదు స్టేటస్ కో వలన. చంద్రశేఖర్ రెడ్డి గారు చెప్పినట్టు పార్టీస్ కొట్టుకునే పరిస్థితి రాకూడదు. ఎందుకంటే వీ షుడ్ రికార్డ్ ది రీజన్స్ ఆల్సో. While granting status quo, necessarily we should record the reasons also. Then come back to the, yes sir, supposing status quo is granted, even then appeal is maintainable or only revision to the High Court under Article 227 of the Constitution? How do you advise the parties?
Prefer revision.
Yes sir, anybody? Even then appeal lies. any order any order passed under that provision of law is appealable. No revision lies. Then another thing is, there any limit for disposal of the application for injunction when ex parte injunction is granted? Is there any time limit for disposal of that application? Under 30 days under Rule
3.
Rule 3. It's a new insertion, sir, letter. Rule 3A, capital A. It has to be disposed of within 30 days. Then, last but not least, another important provision of law is Order 40 Rule 1. Order 40 Rule 1. What does it say? Yes, Sama? Appointment of receivers. Appointment of receivers. Then there is one judgment of the Madras High Court when we were together. There was one judgment of the Madras High Court which laid down a principle as long back as in the year 1955. Would anybody say that? AR 1955 Madras? Konchon, half correct, sir.
They laid for 5 principles with regard to that.
5 principles, they are popularly called not Panchasheel by Nehru, Jawaharlal Nehru ji.
No, they are stating like that.
Pancha Sadachar, sir. Pancha Sadachar. Those are the 5 principles laid down by Madras High Court. That is AR 1955. Plaintiff and defendant. Yes, both sides can avail this provision of law. That is AR 2003, of course following the Honorable Supreme Court, AR 2003 Calcutta 178. AR 2003 Calcutta 178. Then who should be appointed as receiver? Who should be appointed as a receiver? He must have certain qualities to appoint because it is an extended arm of the court. Who should be appointed? An independent, impartial, and totally disinterested persons should alone be appointed as receivers. That is AR 2001, Supreme Court 1361. These judgments also may be helpful to you. AR 1997, Supreme Court 164 and 173. Then 1999, 6th volume, Supreme Court cases 545. Then AR 1962, Supreme Court 21. So this is broadly about the interlocutory applications. Then finally, I would like to conclude this with the great words of great sage this country produced, Sri Vivekananda. He said, I quote, లక్ష్యం కోసం అలుపెరుగక శ్రమిస్తుంటే నేడు కాకపోయినా రేపైనా విజయం సాధ్యమవుతుంది. జై హింద్, జై ఆంధ్రప్రదేశ్. థ్యాంక్ యూ వెరీ మచ్.
అలాగే సోదరి బిఎస్ భానుమతి గారు, అలాగే వేదికని అలంకరించినటువంటి ఈ కార్యక్రమాన్ని నిర్వహిస్తున్నటువంటి పేరున అంటే ఇప్పటికే సమయం చాలా మించిపోయింది. అందుకని సింపుల్గా ఆఫ్ ది డయాస్ ఆన్ ది డయాస్ అంటే పోతుందేమో. ఇందులో రాబోయే ముందే రామారావు గారు హింట్ ఇచ్చారు, సార్ లంచ్ టైం అవుతుంది. నిజమే, అందరికీ లంచ్ టైమే. అందుకని అందులో లిమిటేషన్ యాక్ట్ చెప్పమన్నారు. ప్రత్యేకించి నేను యాక్ట్ గురించి మీకు ఎంతవరకు చెప్పగలనో లేదో కానీ యాక్ట్ గురించి చెప్పబోయే ముందుగా 7 సంవత్సరాల క్రితం అనే ఒక కార్యక్రమం ఇక్కడ బార్ కౌన్సిల్ వారు జరిపినట్టుగా 6-7 సంవత్సరాలు ఉంటున్నారు. ఆ కార్యక్రమంలో మీలో ఒకడిగా కూర్చొని అప్పుడు శేషాయి గారు ఇప్పుడు సిపిసి గురించే చెప్పారు అని గుర్తు నాకు. ఈరోజు నేను డయాస్ మీద కూర్చొని మీ అందరికీ లేదా నాకు అంటూ ఒక సబ్జెక్ట్ చెప్పమని చెప్తున్నారు. అందువల్ల సాయి గారు సిపిసి చెప్పిన తర్వాత ఆయన చెప్పిన విధానంలో నేను జడ్జి అయిన తర్వాత మొట్టమొదటి సెమినార్గా ఈ కార్యక్రమానికి వచ్చిన ఆల్మోస్ట్ ఒక సబ్జెక్ట్ గురించి మాట్లాడమని చెప్పడానికి. సో జడ్జిగా సబ్జెక్ట్ ఎలా చెప్పాలి, ఏదో న్యాయవాదిగా ఆర్గ్యుమెంట్లు చెప్పాను 30 సంవత్సరాలు, అదేదో దాన్ని గుర్తించి ఒక జడ్జి పదవి వచ్చింది. ఆ పదవిలో భాగంగా ఈరోజు మేము ముందుకు వచ్చి అయితే ఆ సబ్జెక్ట్ ఎలా చెప్పాలి మీకు అని అనుకుంటే సాయి గారు చెప్పిన తర్వాత జస్టిస్ సాయి గారు తన సహజ వాక్చాతుర్యంతో సహజ శైలిలో మీ ముందు సిపిసి చెప్పిన తర్వాత మేము లిమిటేషన్ యాక్ట్ చెప్పినా సారీ మా సోదరి భానుమతి గారికి కూడా చెబుతున్నాము, మనం ఏం చెప్పినా అది కొంచెం కష్టంగా ఉంటుందేమో. ఎందుకంటే వీ హ్యావ్ టు లెర్న్. భానుమతి గారు నేను ఒకేసారి జడ్జీలమైనాం. అయితే నేను ఓపెన్ డయాస్లో చాలాసార్లు మీ అందరి ముందుకు వచ్చి ఉన్నాను. అలాగే రాష్ట్రంలో కూడా చాలా చోట్ల ఓపెన్ డయాస్కి వెళ్ళున్నాను. నాకు తెలిసి భానుమతి గారు బహుశా ఇదే మొట్టమొదటి కార్యక్రమం ఉండొచ్చు ఇలాంటి కార్యక్రమానికి హైకోర్టు జడ్జి అయిన తర్వాత ఆవిడ. అందుకని లంచ్ టైంలో మిమ్మల్ని అందరినీ కూర్చోబెట్టి ఎక్కువ సబ్జెక్ట్ చెప్పేసి ఇంకా ఇంకా కొంతమంది ఇదే టైంకి వస్తున్నారు. ఇంకా లంచ్ టైం ఇంకా పెట్టలేదు, ఇప్పుడే వచ్చాము, ఇంకా అయితే కదా అదే టైం అనుకొని వచ్చాం. కానీ ఇంకా వీళ్ళు అదే అండి మా కృష్ణమోహన్ గారు ఏమో ట్రైన్ టైం అవుతుంది వెళ్ళిపోవాలని ఉన్నారు. ఆయన ముందే చెప్పాడు నేను రాగానే, మనోహర్ గారు మీ స్పీచ్ చేయగానే వెళ్ళిపోతారండి నాకు ట్రైన్ టైం అవుతుంది అని అన్నాడు. ఆయన ఎక్కడ కనపడినా ఇదే మాట చెప్తాడండి. ఒక్కోసారి స్పీచ్ వినకుండానే వెళ్ళిపోతుంటారు, అది కూడా తెలుసు. నేను కూడా ఇందాకే మూమెంట్ ఇస్తే వెళ్ళిపోతున్నాడు కావాలని అనుకున్నాను. మరి ఆయన సీనియర్ బార్ కౌన్సిల్ మెంబర్గా ఉత్తరాంధ్ర నుంచి ఉన్నటువంటి సీనియర్ మెంబర్. పోతే నేను 7 సంవత్సరాల క్రితం వచ్చి ఒక అడ్వకేట్గా కూర్చొని మళ్ళీ ఈరోజు మీ ముందుకు రావడం. అయితే నాకు ఇంకోటి ఇప్పుడే ఇందాక మాటల్లో కూడా బార్ కౌన్సిల్ వారి ఆధ్వర్యం జరుగుతున్నటువంటి ఈ కార్యక్రమాన్ని చూసిన క్రమంలో వాళ్ళు గోవాలో బార్ కౌన్సిల్ ఆఫ్ ఇండియా వారితే ఒక యూనివర్సిటీ స్థాపించి దాని ద్వారా కూడా లీగల్ ఎడ్యుకేషన్ అండ్ రీసెర్చ్ ప్రోగ్రామింగ్ని తీసుకెళ్తున్న క్రమంలో నేను లాస్ట్ సాటర్డే అనుకోకుండా గోవా వెళ్ళటం జరిగింది. ఆ యూనివర్సిటీని కూడా నేను విజిట్ చేసి రావడం జరిగింది. బహుశా ఇక్కడ ఉన్న వాళ్ళలో బార్ కౌన్సిల్ మెంబర్లందరూ దాన్ని ప్రత్యక్షంగా చూసి ఉండొచ్చు. ఆ తర్వాత నేనే చూశానేమో. ఇట్స్ వెరీ వర్త్ఫుల్ యూనివర్సిటీ. ఒక లీగల్ ఎడ్యుకేషన్, అక్కడ ఉన్నటువంటి లైబ్రరీ కానీ, అక్కడ ఉన్నటువంటి ఇన్ఫ్రాస్ట్రక్చర్ కానీ, అసలు దాన్ని అక్కడ జరుగుతున్నటువంటి రీసెర్చ్ ఓరియంటేషన్ క్లాసెస్ కానీ చూసిన క్రమంలో వారు కూడా అలానే ఒక యూనివర్సిటీ స్థాపించడమే కాకుండా ఈ బార్ కౌన్సిల్ వారు ఇలా జిల్లాని ప్రాతిపదికగా తీసుకొని కార్యక్రమాలు జరపడం. రామారావు గారు చెప్పినట్టు సంవత్సరం నుంచి ప్రకాశం జిల్లాకి కార్యక్రమాన్ని పెట్టాలనుకుంటున్నాను, కానీ పెట్టలేకపోయినాను, ఆలస్యం జరిగింది అన్నట్టుగా చెప్పుకొచ్చారు. అదే ఇప్పటికైనా ప్రకాశం జిల్లాలో ఇటువంటి ఒక కార్యక్రమాన్ని నిర్వహించినందుకు ఆయన చైర్మన్గా, ప్రకాశం జిల్లా వాసిగా మీకు ధన్యవాదాలు తెలుపుకుంటున్నాను సార్. భవిష్యత్తులో ఇంకా ఇటువంటి కార్యక్రమాలు జరపాలి. సో ఇటువంటి కార్యక్రమంలో నిజంగా నేను ఎంతవరకు అడ్వకేట్స్ పార్టిసిపేట్ చేస్తారని అనుకున్నాను. నాకు గుర్తొస్తున్నంత వరకు ఇక్కడ పార్టిసిపెంట్స్లో ఉన్న వాళ్ళల్లో దాదాపుగా ప్రకాశం జిల్లాలో అన్ని బారుల నుంచి కూడా మెజారిటీ ఆఫ్ బార్ అసోసియేషన్స్ వచ్చాయనేది నేను గమనించాను. అటు చీరాల కావచ్చు, అద్దెం కావచ్చు, మార్కాపురం కావచ్చు, వదిలి కావచ్చు. అయితే వాళ్ళందరితో కలుపుకొని ఈ స్ట్రెంత్ కనపడుతున్నది. ఒంగోలులో ప్రాథమికంగా ఒంగోలు అడ్వకేట్లు ఉండవలసినటువంటి అవసరం ఉంది. వారు ఈసారి ఇటువంటి కార్యక్రమాలు జరిగినా వాటికి మిస్ కాకుండా వస్తారని నేను కోరుకుంటున్నాను. అయితే లిమిటేషన్ యాక్ట్ గురించి చెప్పన్నారు కాబట్టి 2 ముక్కలు చెప్తానండి. ఎందుకంటే నేను గత 6 నెలలుగా సివిల్ సైడే వర్క్ చేస్తున్నటువంటి పరిస్థితి. సిఆర్పీలు చూశాను. ఒక 3 నెలలు 3.5 నెల సివిల్ డివిజన్ క్వశ్చన్స్లో ఈ లిమిటేషన్ యాక్ట్ కింద వచ్చే రివిజన్స్ చూసిన క్రమంలో సాధారణంగా అడ్వకేట్స్, న్యాయవాదులుగా మీరు వేస్తున్నటువంటి పిటిషన్స్ అయితే ఇప్పుడు వస్తున్నటువంటి బ్రష్ మ్యాటర్సే కాకుండా ఓల్డ్ మ్యాటర్స్ కూడా చూడడం జరిగింది. అయితే ముఖ్యంగా ఈ లిమిటేషన్ యాక్ట్కి సంబంధించి మీరు సెక్షన్ 5 కింద వేసే పిటిషన్స్లో చూస్తున్నప్పుడు సరే హైకోర్టు దాకా గెలిచిన వాటికన్నా అంటే ఏ పిటిషన్ ఎలవైన పిటిషన్ల కన్నా కూడాను డిస్మిస్ అయిన పిటిషన్ల మీదనే అంటే ఇరు పార్టీల వారు వస్తారు రివిజన్స్కి. అటు ఓడిన పిటిషన్ ఎలవైనా డిస్మిస్ అయినా ఎక్కువ డిస్మిస్ అయిన పిటిషన్లే ఎలవైన పిటిషన్స్ కన్నా కూడా డిస్మిస్ అయిన పిటిషన్ల మీద ఎక్కువ రివిజన్స్ ఉంటాయి కంపారిటివ్. నేను చూసిన క్రమంలో నా దగ్గరికి ఈ 2-3 మంత్స్లో లిస్ట్ అయిన కేసుల్లో ఎక్కువ ట్రయల్ కోర్టులో డిస్మిస్ అయ్యి వాటి మీద రివిజన్, అఫ్కోర్స్ ఎలో పిటిషన్స్ కూడా వాటి మీద రివిజన్స్ వచ్చినటువంటి వాస్తవం. అయితే అసలు ఈ కాల పరిమితి ఏమిటి, మీరు ఎలా మీరు ఎలా సెక్షన్ 5 కింద పిటిషన్లు ఏ కారణాలతోటి ఎలా చూపించి వేయగలుగుతున్నారు అనే అంశాన్ని చూసినప్పుడు ట్రయల్ కోర్ట్స్లో ఉన్నటువంటి న్యాయవాదులు మీరు ప్రత్యేకించి పిటిషన్ వేయడానికి ఆ పిటిషన్ వేసిన క్రమంలో దాన్ని ఎలా ప్రాసిక్యూట్ చేస్తే బాగుంటుంది అన్నటువంటి బేసిక్ ఇష్యూని విస్మరిస్తున్న మాట వాస్తవం అండి. అది గ్రహించాలి. ఏదో వెరీ క్యాజువల్ మేనర్లో ఏదో ఒక మ్యాటర్లో ఎక్స్పర్ట్ అయి ఉన్నారు, సెట్ ఎక్స్పర్ట్ అయింది, డిగ్రీ అవుతుంది, వస్తున్నారు, మిమ్మల్ని పార్టీలు అప్రోచ్ అవుతారు, మీరు ఆర్డర్ 9 ఆర్డర్ 9 రూల్ 9 అలాంగ్ విత్ 6 పిటిషన్స్ వేస్ట్ చేస్తున్నారు. వేసి మీరు పిటిషన్ వేస్తున్న క్రమంలో అసలు బేసిక్గా డిలేని మనం ఎలా ఎక్స్ప్లెయిన్ చేయగలగాలి, ఎందుకు నేను పలానా రోజున కోర్టుకు రాలేకపోయినాను, ఆ రాలేకపోయినటువంటి క్రమంలో తర్వాత జరిగిన ఆలస్యానికి కారణం ఏంటి, ఆ కారణాన్ని నేను కోర్టు ముందు సరిగా చూపించగలిగానా అన్న అంశాన్ని మీరు ఎంతమంది న్యాయవాదులు దాన్ని సీరియస్గా అబ్జర్వ్ చేస్తున్నారు అన్న విషయాన్ని గమనిస్తే చాలా క్యాజువల్గా పిటిషన్ వేస్తున్న పరిస్థితి. ఫర్ ఎగ్జాంపుల్ ఓ మెడికల్ గ్రౌండే తీసుకుంటారు, దాన్ని సబ్స్టాన్షియేట్ చేయడానికి సఫిషియెంట్ డాక్యుమెంటరీ ప్రూఫ్ ఇస్తున్న పరిస్థితి లేదు. ఆ పరిస్థితిలో ట్రయల్ కోర్టు ఏం చేయగలరు చెప్పండి? ఎందుకు మెడికల్ సర్టిఫికేట్ దాఖలు చేయని పరిస్థితి? మెజారిటీ ఆఫ్ కేసెస్ చిన్న ఓకే మీరు చెప్తున్న రీజన్ ఏదైనా కావచ్చు, ఆ రీజన్కి సంబంధించినంత వరకు ఆ రీజన్ని సబ్స్టాన్షియేట్ చేసుకోవడానికి మీరు చేస్తున్న ప్రయత్నం ఏంటి? కోర్టుని, అక్కడ ఉన్నటువంటి మీ ట్రయల్ కోర్ట్ జడ్జి గారిని ఎంతవరకు మీరు ఆ విషయాన్ని అలౌ చేయడానికి మీరు మీ ప్రయత్నంలో ఎంతవరకు సిన్సియారిటీ కనపడుతుంది అనేది చెప్పాలి అంటే అది చాలా తక్కువ కనపడుతుంది. అది సబ్స్టాన్షియేట్ చేసుకోవడానికి ఒక మెడికల్ గ్రౌండ్ తీసుకున్నప్పుడు ఒక చిన్న డాక్టర్ సర్టిఫికేట్ ఫైల్ చేసుకోవాల్సినటువంటి అవసరాన్ని గుర్తించకుండా అంత మెకానికల్గా పిటిషన్ ఎందుకు ఫైల్ చేసేవలసినటువంటి పరిస్థితి ఉంటుంది అనేది తెలియక అంటే కొంత తెలిసి తెలియక అని కరెక్ట్గా నేను చెప్పాలని ఒక తేలిక భావం, వృత్తి పట్ల పూర్తి నిబద్ధత కలిగి ఉండి మనం ఎటువంటి పరిస్థితుల్లో మన దగ్గరికి వచ్చినటువంటి పార్టీని మనకు న్యాయం చేయగలుగుతాము అన్నటువంటి ఒక నిబద్ధతతో దాన్ని చేయలేకపోవడమే ప్రధానంగా. ఎందుకంటే ఈ రోజున మీకున్నటువంటి ఫెసిలిటీ ఆ రోజున మేము ప్రాక్టీస్ చేసే రోజుల్లో మాకు దాన్ని తెలుసుకునే పరిస్థితి లేదు. జడ్జిమెంట్లు కావాలన్నా, ఏదైనా బుక్స్ రెఫర్ చేయాలన్నా ఎక్కడికో వెళుతున్నటువంటి పరిస్థితి, ఎక్కడికో వెళ్ళి తీసుకోవాల్సినటువంటి పరిస్థితి ఉండేది. బట్ ఈ రోజున మనం అందరం వాడుతున్నటువంటి మొబైల్స్లో మనం ఉన్నటువంటి గూగుల్ వాడుకుంటున్న విషయంలో అందరికీ తెలుసు. మరి అందులో లీగల్ పొజిషన్ ఎంతవరకు కనపడతా ఉంది, అట్లీస్ట్ దాన్ని స్టడీ చేసైనా ఒక పిటిషన్ కోసం పిటిషన్ వేస్తున్నాం, మనం ఒక వేస్తున్నాం, దాన్ని వేస్తున్నామంటే ఏమన్నా సెటిల్డ్ లీగల్ ప్రపోర్షన్స్ ఉన్నాయా ఇందులో? ఆ లీగల్ సెటిల్డ్ ప్రపోర్షన్ చూసుకొని ఆ బేసిస్లో దాన్ని మీరు ఫైల్ చేస్తే బాగుంది. దానికోసం ఎందుకో మీరు టైం వెచ్చించడానికి సిద్ధపడట్లేదు. ఏదో కేసు వచ్చింది, పిటిషన్ ఫైల్ చేస్తున్నాం, పార్టీ అడిగాడు, ఏమంటే పిటిషన్ వేసామండి, అయిపోయింది, జడ్జి గారు కొట్టేసినట్టున్నారా, హైకోర్టుకి వెళ్దాం అనే ఆలోచన తప్పితే అసలు నిజంగా మనం చేయగలుగుతున్నా, దాని మీద సిన్సియర్గా మీరు పెడుతున్నటువంటి ఎఫర్ట్ ఏమిటి అనేది ఆలోచించుకోవాల్సిన అవసరం ఉంది. మీరు చేయగలరు. చాలా సింపుల్ ఇష్యూస్. అసలు డిలే కాండనేషన్ విషయంలో ఎంత డిలే ఉన్నప్పటికీ సుప్రీంకోర్టు చెప్తున్నటువంటి పరిస్థితిని కనుక ఇచ్చినటువంటి జడ్జిమెంట్లు కనుక ఇప్పటి వరకు ఉన్నటువంటి సెటిల్ లీగల్ పొజిషన్ గమనిస్తే మీ అందరికీ కూడా తెలిసిన విషయం. జనరల్ సీనియర్ అడ్వకేట్స్కి ఇక్కడ తెలుసు, జూనియర్ అడ్వకేట్స్ తెలియలేకపోవచ్చు, వాళ్ళు తెలుసుకోవచ్చు చాలా ఈజీగా. ఈ రోజున్నటువంటి ఇన్ఫ్రాస్ట్రక్చర్ మన దగ్గర ఉన్నటువంటి అవకాశాలు పెరిగిన క్రమంలో దాన్ని తేలిగ్గా తెలుసుకోవాల్సినటువంటి పరిస్థితులు ఉన్నాయి. అవి తెలుసుకొని చేసుకోవచ్చు. ఎటువంటి పరిస్థితులైనా ఏ కోర్టు అయినా కూడా క్యాజువల్గా తీసుకోకుండా, రైట్స్ ఆఫ్ ది పార్టీస్కి ఎటువంటి ఎఫెక్ట్ జరగకుండా చూస్తూ, బ్యాలెన్సింగ్ ఇష్యూస్ చూసుకుంటూ సెక్షన్ 5 క్వశ్చన్స్ ఎలా చేయాలి అనేది సుప్రీంకోర్టు చెప్తున్నది. బట్ మీరు ఎంతవరకు దాన్ని ట్రయల్ కోర్ట్స్లోనే దాన్ని రెస్ట్రిక్ట్ చేసుకునే పరిస్థితిని తీసుకురాకుండా ఏదో క్యాజువల్గా వేసి అలా అంటే క్యాజువల్గా నేను అనట్లేదు, దాంట్లో కొంత లిటిగేషన్ పార్ట్ కూడా ఉందని అనుకోవాలి. అన్నీ విడమర్చి చెప్పడం గురించి కాదు, కానీ అంటే అకాడమిక్ పాయింట్ ఆఫ్ వ్యూలో ఆలోచించినప్పుడు ఏ విషయాన్నైనా క్షుణ్ణంగా తెలుసుకొని, ఆ రోజున మేము సీనియర్ అడ్వకేట్ దగ్గరికి వెళ్ళాలి ఏదైనా తెలుసుకునే పరిస్థితి ఉంటే, ఈ రోజున అది లేదని చెప్తున్నాను. మీరున్న చోటనే మీరు ఎక్కడైతే మీ ఇంట్లో మీరు కూర్చొని మీరు ఇంట్రెస్ట్గా మీరు చూసుకోగలిగితే ఎన్నో లీగల్ స్టేటస్లు ఈ రోజున మన మొబైల్లో కనపడుతున్నటువంటి అంశం. దాన్ని మించి ప్రత్యేకించి అకాడమిక్గా మీరు ముందుకు వెళ్ళే ఆలోచన ఉంటే తప్పకుండా ఈ టెక్నికల్గా మనం వీటిని ఉపయోగించుకుంటే మీ అందరికీ చాలా ఉపయోగకరంగా ఉంటుందనేది నాకున్నటువంటి. అలాగే ఇంకా ఎన్నో చిన్న విషయాల్లోనే మేజర్ ఇష్యూస్ గురించి చెప్పలేదు. అబ్నార్మల్ డిలేస్ ఉండి వాటిని ఎలా చేయాలి అన్న దాని గురించి అల్టిమేట్గా ఎవరు డిసైడ్ చేస్తారు దీన్ని అనే అంశాన్ని పక్కన పెడితే, క్యాజువల్గా చూస్తున్నటువంటి విషయాల్లో నేను గమనించినటువంటి పరిస్థితిని మీ అందరి దృష్టికి ఒకసారి తీసుకురావాలని ఆ విషయాలన్నీ కూడా మీరు పూర్తిగా గ్రహించాలని కోరుకుంటూ నాకు ఈ అవకాశం ఇచ్చిన ఇంకోసారి మళ్ళీ మేము అందరినీ ప్రత్యేకించి ఇలాంటి సెమినార్లు కలవడానికి అవకాశం వస్తుందని అనుకుంటూ ఇలాంటి కార్యక్రమాలు ఇప్పుడు చేసినా ఇలాంటి మన బార్ కౌన్సిల్ చైర్మన్ గారు కూడా చెప్పేది ఏంటంటే నేను ఒక షార్ట్ టైం అని కాకుండా కొంచెం లీజర్గా అందరు మేము చెప్పదలుచుకున్నది పూర్తిగా చెప్పాలన్నా కూడా అందరికీ అటువంటి కొంచెం ప్రోగ్రాం లెంతీగా ఉండే విధంగా పెట్టాలని చెప్పి సరే అని తెలియపరుచుకుంటూ నాకు ఈ అవకాశం ఇచ్చినటువంటి మీ అందరికీ ధన్యవాదాలు తెలుపుకుంటూ సెలవు తీసుకుంటాను.
థ్యాంక్ యూ సార్. అంటే ఈరోజు కనుక మనం నేను చెప్తా ఉంటాను లైట్ లంచ్ చేసి మళ్ళీ రండి అని. అలా కాకుండా సంప్టువస్ లంచ్ చేయడానికి ఫెసిలిటేట్ చేయడానికే అసలు లంచ్ తర్వాత సెషన్ ఏం పెట్టలేదు. అందువల్ల వారి సలహా మేరకు ఈసారి లంచ్ తర్వాత కూడా మళ్ళీ సెషన్ పెట్టుకుందాం. Now I request Justice Bormati Garu to present on Evidence Act and Relevancy.
సభాయ గురుతుల్యులు ఏకలవ్య శిష్యులు శ్రీ జస్టిస్ బ్రదర్ శేషయ్య గారు, ల్యాండ్ శ్రీ గంటరామారావు గారు, President of the Bar Association, members of the Bar Council, on the dais, off the dais, all the senior councils, junior councils, and student friends, and the media. ముందుగా అందరికీ నా నమస్కారాలు. Today I take it as a privilege to share my knowledge with all of you. As Brother Justice Sai Garu said, it is the only thing which can be increased by sharing. When we light the lamp, while we light the lamp in any auspicious occasion it is equal to knowledge. It's very apt to commence the programs of this kind with lighting lamp. When we are in dark, we have every fear. Even we cannot take a step forward, or we cannot even stand where we are because we are shrouded with fear. We do not know what is around us. Whereas light gives us strength, knowledge of what is around us, so that we can take a decision. That's how we always compare the knowledge with light. I suppose that our custom of lighting lamp is with this object. I am indeed delighted to see so many students who are participating here. When Sri Ramarao asked me, I do not know what would be the range of the audience. Am I to address only the senior councils who are already well versed and how to share my knowledge with the seniors, or should I address juniors with whom I need to take a different approach? But today it is a mixture of the audience, and my task is more difficult. It is more difficult, as Justice Manmadra said, we commence with very sumptuous lunch of sharing knowledge by Justice Sai Garu. I make my own effort. When we think of evidence, we get so many doubts. What to choose, how to present. So it presupposes what are the issues involved, what are the facts to be proved in support of decision on the issues. Because a lot of students are here, I would like to know what is evidence. Is it defined anywhere as? Yes, it is defined in the Evidence Act itself, because section usually in any enactment, the words which are used and which have importance in the act, they are defined in the first provisions of the enactment. I suggest all the students to read any enactment bare act before you know any subject. If you want to write, you first learn alphabetical letters and then short forms and then sentences. Letters, words and sentences. So also when we learn law, we should start with reading a bare act. For understanding the provisions in the bare act, the opening sections would be always definitions. So the Evidence Act also did not leave the space to understand what is evidence. So if we look at the definition of evidence, it says, evidence means and includes. What does it give us the sense? It defines not only its meaning, but it is also inclusive. It means that rules of interpretation say us that it is not exhaustive. All statements which the court permits are required to be made before it by witnesses in relation to matters of fact under inquiry. So it includes all statements made before the courts, and it also includes all documents, whether electronic records or not, produced for the inspection of the court. Such documents are called documentary evidence. So either it can be a statement or it can be a document. And because we have limited time, I want to touch a little confusing areas for the more benefit of the students rather than the seniors. So document, what does it mean? Is it a piece of paper? Or we see in criminal cases, a knife with bloodstains would be produced, or a cloth with bloodstains would be produced, and the like. So if evidence is permissible under only two classes, document and statement. Statement is oral evidence. Document is a statement contained in a document, transaction contained in a document. Then where is the occasion to lead evidence of we are producing sticks, we are producing knives? How is it possible? Under which class do we classify this type of evidence? Can I have assistance from the audience? Is this oral evidence or documentary evidence? If not both, then what? Because time is too short, I tell you the answer as it falls under the category of document. So only two kinds of evidence is allowed before the courts. Okay? Then the question would be, There are thousands of facts around us which may be untrue, which may be true. If we start taking evidence of every fact which is known to us, there is no end to close any case. So, the law says only those facts which are in issue or relevant to the fact in issue should be allowed. Therefore, a limited scope is limited in section 5 of the Evidence Act. When it says, evidence may be given in any suit or proceeding of the existence or non-existence of every fact in issue and of such other facts as are hereafter declared to be relevant. It did not stop there. It says no others. If it is stopped there, some other may argue because it is not negatively also said, it can be. So they did not leave opportunity of argument. They closed. So then the facts which are in issue and facts which are relevant to the issue, then only they can be permitted, nothing else. What does it mean? For example, if it is a suit for recovery of money based on promissory note, you can lead evidence relevant to that, or the issue could be mainly whether plaintiff lent money to the defendant. What all is required to prove that issue should be allowed, nothing else. If a dark box at that time, maybe it is a true fact, but it has nothing to do with this case. But that may be a relevant fact in any other case, a case involving criminal matter, it may have some relevance. Therefore, what is in issue and what is relevant, unless we don't know these two concepts, we cannot lead evidence. Everything is not permitted to be let in evidence. Therefore, the chapter of relevancy is in Evidence Act, starting from section 5 ending with section 55. Now, at this juncture I may tell you one thing. New amendments are likely to be brought in. They are at the nascent stage. I have gone through that proposed bill also. It is almost analogous to the existing law insofar as relevancy and the definitions are concerned. The only difference I could find is they renumbered it, and at some places they merged the provisions which are presently existing. Nothing, no change. So the same law which exists as on day may also continue unless some more amendments are suggested during the course of deliberations in the Parliament. When we said relevant, we now said fact in issue and relevant. Of course, they are also defined in the Act itself. Skipping that, but I would like to tell you only one thing. Relevancy is more relevant because I have taken the concept of relevancy. I would read. One fact is said to be relevant to another when one is connected with the other in any of the ways referred in the provisions of this Act relating to the relevancy of facts. So the chapter dealt with in so many provisions as to what is relevant, what is not relevant, what is irrelevant, whether it is conclusive proof or proof or not proof. Though the chapter is titled Relevancy, it speaks of proof, it speaks of relevancy, irrelevancy, whether it is conclusive proof, and so many details are provided. So, starting from Section 5, which controls us to lead evidence only of relevancy. From section 6, it starts saying what is relevant. On practical side of it, as advocates, we tend to ask more questions. We tend to produce more evidence. But at that juncture, sometimes there is conflict from bench and bar. Sometimes there is misunderstanding that courts are harshly refusing to lead evidence. Maybe there is sometimes misunderstanding on the other side also. But on both sides, the measure is the Evidence Act. We must keenly analyze whether any fact which we want to lead evidence is governed by the provisions of relevancy or not. Then the question would be, who would decide relevancy or admissibility? Who? Is it the party? Is it the council? Or is it the judge? Who to decide the admissibility of evidence? May I have any answer from the audience? If anybody says the answer, I want reference also. Who to decide the admissibility? Section 136 says, judge to decide the admissibility of evidence. When either party proposes to give evidence of any fact, the judge may ask the party proposing to give the evidence in what manner the alleged fact, if proved, would be relevant, and the judge shall admit the evidence if he thinks that the fact, if proved, would be relevant and not otherwise. If the fact proposed to be proved is one of which evidence is admissible only upon proof of some other fact, such last mentioned fact must be proved before evidence is given of first mentioned. It reads further, but I would like to emphasize only 2 points from this provision. It is ultimately the judge who takes the decision on admissibility. So, what the duty of the council is to impress the court within the parameters of law, how it is relevant and how it is admissible. For a new entrant, many a time there is scope for confusion, admissibility with the relevancy, admissibility with the proof. Each has its own meaning and connotation. Any of them cannot replace the other. A fact which is relevant may not always be admissible. For example, a document which contains the transaction of a lending and undertaking to repay is relevant, because in a suit for promissory note, when the plaintiff says, I lend money to the defendant, and the defendant denies that he did not receive the money, then the issue would be whether the plaintiff has lent the money. So it is directly an issue, and the fact is recorded in a promissory note. So that is a fact which can be adduced in evidence. Then is it just because relevant admissible in evidence? No, because there are, apart from the provisions in the Evidence Act, there are other enactments which govern the same. In the Evidence Act itself, the other provisions say, whenever a fact is to be proved, it must be only by primary evidence. In certain circumstances, secondary evidence. So the primary evidence is the original promissory note itself. Secondary evidence can be in more forms. Therefore, these are one kind of limitations, admissibility, which are governed by the Evidence Act. But when we go to the Stamp Act also says unless there is certain amount of stamp duty paid on it, such document cannot be received in evidence, Section 35 Stamp Act. And the amount of stamp duty liable to be paid in relation to every instrument is mentioned in 2 schedules annexed to the Stamp Act. Therefore, unless the promissory note bears the stamp required as per the Stamp Act, it is inadmissible in evidence. Therefore, whatever is relevant may not be always admissible, but vice versa is true. Whatever is admissible is relevant. Therefore, admissibility, relevancy, and proof is third aspect. Proof is again defined in the Evidence Act. The understanding of the proof again goes to the discussion of the court. It applies the test of a prudent man. Just because a promissory note is filed, does it mean that the transaction is proved? Just because a scribe or a attestor to the document is examined, does it amount to proof? There, why are we cross-examining the witnesses? Why are we taking the assistance of opinion of an expert? These are all to prove non-existence of a fact. The scribe might say, I scribed this document on such a certain date, but by examining by other means like age of the ink or the revenue stamp which bears may be of recent date, but it may not be of the year on which date it is said to be executed. By leading this kind of evidence, the non-existence of the fact is proved. That is how law permits not just to prove a fact, but proving a non-existence of fact can also be proved. For this, the measure is a definition of proof. It permits the test of a prudent man. Prudent man under ordinary circumstances, how would he feel? Is it sufficient to prove that fact or is it not sufficient? Again, ultimately the discussion is with the court. Court decides, of course, by using its judicial discussion guided by the settled principles and standards required. The standard required in case of the very same fact in civil matters, though Evidence Act doesn't make any difference as to the standard of the evidence required, by decisions of Supreme Court and constitutional other courts, we have the principles developed, evolved over the years. The standard of proof required in civil cases is preponderance of probability. Then what is preponderance of probability? If it exists, because he is a man of trustworthiness, what he said must have been true. What he said is also supported by a reliable document coming from a source, so it is possible. This is all preponderance of probability. The plaintiff said, I lent, and it is also supported by the promissory note signed by the defendant, and the other witness also came and said it is that transaction took place. and nothing is elicited from the evidence of those witnesses to distrust them. Therefore, the court takes that as proved. But when it comes to criminal cases, the degree of proof required is on higher pedestal because we adopted the principle that presumption of innocence. The accused is always presumed to be innocent. The guilt must be proved against him. And the proof of guilt is also stands on higher pedestal beyond reasonable doubt. We must see that all that evidence which may give us some thinking that it must not have happened should all be removed. Then we call it beyond reasonable doubt. So what kind of degree of proof required in a particular case depends on the nature of the case. But the Evidence Act is same for both cases or in all cases. Therefore, when we come to the proof admissibility, we may have to refer some other provisions quickly. The relevancy of chapter on relevancy deals with admissions, confessions, and statements made by the deceased persons or such other kind, though alive, if their presence cannot be easily secured, and so on, even opinions of experts, judgments, acts, orders, decrees, everything. Without going deep into all these provisions, I would like just to give some clues to the students how they should understand the provisions. In a case of murder, there is no direct evidence. Therefore, we depend on circumstantial evidence, as you must have heard. All these circumstances put together, when each fact of circumstance is proved as required under the Evidence Act, a chain of circumstances would be proved so that ultimately it will be decided that A committed murder of B. Then, to commit murder, there must be some reason. That is what we call motive. For example, A has done something to B or B's relatives so that B developed some grudge against A and committed murder. So that is the motive for commission of the murder. Therefore, motive is relevant. Otherwise, in any other transaction or case, motive is not relevant. In a suit for recovery of money based on promise note, is motive relevant? Lending itself is sufficient. Undertaking to repay itself is sufficient. Motive has no role. Motive is, when relevant, a fact is relevant which shows or constitute a motive or preparation for any fact in issue or relevant fact. Question. When you put a question, you expect an answer. That answer must speak of some fact, and that fact, unless relevant under any of the provisions, you are not permitted to put that question. But sometimes you demand, I am asking this question, the witness said this question, please record it. As I said, admissibility and relevance can be decided by the judge. So then your duty and obligation comes You must show how and under what provision of law it is relevant. Why are we referring to provisions while sharing knowledge with you also to indicate whenever as an advocate, when you speak before a court, you're not supposed to behave like a layman because you are learned, because you are lawman, not a layman. You must substantiate whatever argument you propose with the proposition of law. Law form based on some substratum. If judges opposes not to record, you must be able to show that this is the fact which I want to elicit and this is the provision of law under which it is relevant. That's why I am putting this question. You can't just enter into quarrel. You just exhibit your knowledge based on law. That is what is expected. If that happens, that kind of articulation, that kind of presentation has to be learned by juniors from the seniors. How they conduct themselves, how they present, how they behave, how they convince. Therefore, I am giving this example to understand and read every bare provision of law. Before you go into any decisions, first of all you read. As students of law, you must first of all develop the habit of reading the bare provision, try the area. That's how I mean, and I'm pointing out some examples how to comprehensively read and understanding a subject. And now I quickly move on to the admissions. We say on the bench, hearing from the other side, this fact is admitted, therefore I need not prove. Adopting the test of proof as per the definition of Section 3 of Evidence Act. Again, a court can ask further proof other than the admission. Therefore, my dear friends, please have a comprehensive look of all provisions. Am I within time or beyond? The fact admitted can still be, so with your experience you can assess reasonably whether with the admitted fact you are able to convince the court as that fact proved, or does it require something more? Admissions can be used against its maker. If I make a statement, I have borrowed, it is admissible against me. But if I say I did not receive, this is also a statement, but it is in my favor. That statement is in my favor. I cannot use it. Section 21 says, admissions are relevant and may be proved as against the person who makes them or his representative interest, but they cannot be proved by or on behalf of the person who makes them. But it did not end there. It has provided some exceptions, except in the following cases. An admission may be proved by or on behalf of the person making it when it is of such a nature that if person making it were dead. So it has brought in the concept of Section 32 of the Evidence Act, which allows, it is a general, Section 32 is an exception to the general principles of law. What does evidence say? The evidence must be led of primary evidence. Only when primary evidence is not available, secondary evidence. When a person who died said something, he is not available to make this same statement before a court because he died. But how to prove what he said? It is permitted under section 32. Therefore, it is an exception. But if that be the circumstance, it can be brought within section 21. An admission may be proved by or on behalf of the person making it, when it is of such nature that if person making it were dead. That analogy is brought in. We should never be confused that it is only the dead person's statement which is covered by 21. What is already covered in other provision is never repeated in the wisdom of the legislature. The principles of interpretation of law say the wisdom of legislature has always a higher pedestal. We must presume that they know it. It is already covered in another area, so never they try to repeat. Therefore, the circumstances which bring that case within the parameters of law, section 32, under those document, if it is an admission, moral evidence of it cannot be given because section 90, 91, 90, there is a prohibition. When a transaction is governed by a document, moral evidence of that document is not permissible. So there will not be any concrete an exception unless and until the party opposing to prove them shows that he is entitled to give secondary evidence of the contents of the document under the rules in the question. These are the exceptions. The term civil cases is for the first time used in section. It says in civil cases no admission is relevant, that evidence of it is not to be given, or circumstances from which the court can infer that parties agree together that evidence of it should not be given. But exceptions are provided. The exception is section 126 of the evidence. Then to prove the issue of notice, an advocate may be examined as a witness. Their limitations. He cannot be asked to reveal everything, but section 126 also provides some exceptions. If the question falls within that exception, again that question can be put. We can elicit an answer from the counsel also. If that is permitted there, it is permitted here also. I want to touch the confessions. Confession is a statement admitting guilt. So it has an element of admission. When we call the term admission, it is a simple meaning. But when we call the same kind of admission, admitting the guilt, we call it as confession. So when an accused confesses that he has done an offense, is it admissible or is it not admissible? I would like to ask the students, is confession admissible or not admissible? The confession statement. So what provisions of law will help us? Nobody would like to answer? It is permissible. There is no absolute bar. Under certain conditions, confessions can be proved against its maker. But certain rules of that it should be made before MRO or a revenue officer? No. There is no format of confession to record confession. But rules of criminal practice would provide certain parameters how it should be conducted. They all are intended to safeguard the interest of the accused. There may be some influence in making such confession. That should also not come in the way. And confession made to police officer is fraud. Confession made during the custody of the police officer, if made before a magistrate, is admissible again. A person might have confessed, tomorrow he must have withdrawn. We call it retract, he said. And the preventive value of confession also will be assessed with the assistance of other circumstances, like before whom he said, how much time he took, did he, was he free, has he free mind when when he made the statement. These are all possible. A person must have made a confession involving himself and also other accused also. That is also not. I am touching all these aspects, not for the sake of seniors who are here, who know better. Just one more thing I would like to ask the students. We take decisions of the court as binding. For that purpose, it is rule of precedent which is enshrined in our constitution. That's why we refer to decisions of the Supreme Court and High Court. But where from we get the authority to refer a certain publication or publication of legislation? Further, Evidence Act says, Section 41 says, relevance of certain judgments, Section 38 says, when the court has to form an opinion as to law of any country, any statement of such law contained in a book purporting to be printed or published under the authority of the government of such country and to contain any such law and any report of ruling of the courts of such country contained in a book purporting to be a report of such rulings is relevant. Therefore, we rely on the Gazette publications, we rely on the published journals to cite before the courts. Finally, I would like to tell you, wherever and whenever you present a case before a court, for every of your action, there is some basis in provisions of law. What you all need to do is, you are all youngsters, still at the stage of developing your knowledge. From day one you start studying with the 3 questions. What is? If you want to argue a bail application, start with the question, what is bail? If court asks you what is bail, you must be able to answer. And then comes to the question, where it is. It is a very common question which you receive from the bench. Where do you find it? You must be able to answer it. You must assist the court. You are also a law officer of a court. Advocate is also officer of a court. Therefore, there is equally burden on you to assist the court to pass a meritorious judgment. The first question is what? The next question is where it is. The third question is how it should be presented. Is there the way to explain what is already there in the code? That's how. Unless you develop the habit of reading any text of law in this perspective, you cannot have the complete control over court proceedings to take them to your own side. I thank the organizers of this seminar to give me this opportunity to share my knowledge on a few aspects. Thank you very much.
It is the first. I only request another 5 minutes. We will quickly finish the process of felicitation. Please kindly bear with us another 5 minutes. We will close the session completely. I request, make it quick, sir.
Please come out to the dais, Sudhakar sir garu. So, without his cooperation, we could not have made it.
Thank you very much to the RIMS.
Krishna Reddy BV sir is being felicitated. Now Chidambaram sir. Next we request Chandrasekhar Reddy garu, please come over here. Chandrasekhar Reddy garu. Next, Sri Brahma Reddy garu, what is Zonala? Followed by Miss Madhavi Madam. Krishna Mohan, yes, get ready please. Now Miss Madhavi Rolla, Madam is being felicitated. Sri Krishna Mohan S, Member Bar Council, Sri Krishna Mohan S. Sri Brahmananda Reddy Somasani. Next, Venkatrama Reddy sir, please get ready. Sri Venkatrama Reddy garu Koguri. Next, Sudarshan Rao sir. Sudarshan Rao sir is requested. Next, Srimati A. Bharati Madam Garu, Principal District and Sessions Secretary, Ongole. Rolla Madhavi Madam, please come out to the dais. Honorable Miss Justice B.S. Bhanumathi Garu, High Court Judge, Andhra Pradesh. Honorable Justice Dr. G. Manmadharao Garu, Judge, High Court. Justice Dr. K. Manmadharao Garu is being well treated by the team. Now, felicitation to Sri Justice A.V. Seshai Garu. Sri A. Ramareddy Garu, Member BCI. Ramireddy Aluru, Member Bar Council of India. Next bar. Now first.
ప్రాసిక్యూటర్స్, న్యాయవాదులు, న్యాయ విద్యార్థులు అందరికీ మా ఒంగోలు బార్ అసోసియేషన్ తరఫున ఈ 1 డే ప్రోగ్రాం ఇంత సక్సెస్ చేసినందుకు అందరికీ ధన్యవాదాలు తెలుపుకుంటున్నాను. ఈ 1 డే ప్రోగ్రాంలో సహకరించిన ప్రతి ఒక్కరికి పేరు పేరున మా ఒంగోలు బార్ అసోసియేషన్ ధన్యవాదాలు తెలుపుతూ అందరికీ లంచ్ ఏర్పాటు చేయడం, ఇప్పటికే టైం చాలా ఎక్కువ అయిపోయింది కాబట్టి అందరికీ మరొకసారి ధన్యవాదాలు తెలుపుతూ అవుట్ ఆఫ్ థ్యాంక్స్ చెప్తాను.
జనగణమన
जनगणमन अधिनायक जय हे भारत भाग्य विधाता पंजाब सिंध गुजरात मराठा द्राविड उत्कल बंगा विंध्य हिमाचल यमुना गंगा उच्चल जलधि तरंगा तव शुभ नामे जागे तव शुभ आशीष मांगे गाहे तव जय गाथा जन जन मंगल दायक जय हे भारत भाग्य विधाता जय हे जय हे जय हे जय 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 हे